This is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for tuning in. If you've got an immigration problem, please get in touch with me and I'll do my best to help you. Today I'm going to be talking about a very sensitive subject, which I'm sure will not please the new Home Secretary, Suella Bravermann, but could help those who have been deprived of their British citizenship. This is a growing problem. The question that I'm often asked is, can I apply for indefinite leave to remain if I have just been deprived of my citizenship on the grounds of fraud or deception? The reason for this is it used to be exceedingly unusual for the Home Office to deprive British citizenship. However, nowadays it has become increasingly common for the Secretary of State to exercise her discretionary powers to take away someone's citizenship. In the years 2017 to 2020 alone, there have been a record 220 people who have been subject to these powers, been stripped of their British citizenship. And we're not talking about just 220 terrorists. What happens, therefore, when someone is deprived of their citizenship? Well, when the Home Office is considering depriving someone of their citizenship, the Secretary of State will first provide that person with an opportunity to make representations, essentially to give them reasons why they should not be deprived. And there are often good reasons, and it's worth getting advice, because I've prevented deprivation in lots of cases. And however, if the Home Office do carry on, then an individual will be afforded a right of appeal under the British Nationality Act 1981. It should be noted that deprivation cases and appeals are exceptionally complex, so it's highly recommended that you seek proper legal advice from a reputable immigration advisor right from the very beginning, right from when you know you're in trouble, rather than not doing it or getting a bad lawyer. Usually if a person decides, we'll take this as an example, not to appeal or they're unsuccessful at their appeal, then the Home Office will take the following steps. They will sign a deprivation order within 4 weeks of an individual's appeal rights being exhausted. Up until that point, even if the appeal has been lost, the person is British until that deprivation order is signed. They will then make a decision on whether to grant the person leave to remain in their real identity or remove them within 8 weeks of the deprivation order being signed. The Home Office will once again, just to make their jobs even more complicated, invite a person to make submissions on why they should be given limited leave to remain, 2.5 years. If they do so, an individual will be placed back on the 10-year route to settlement, and they will have no access to public funds, and they will have obviously precarious immigration status. So the question I'm often asked is, can I apply for indefinite leave to remain straight away, straight after the deprivation? Well, it may be possible there's a bit of a loophole in the law, in that it may be possible for somebody to apply for indefinite leave to remain after being granted discretionary leave for 2.5 years. This might sound really weird, but why? Well, this is down to the immigration rules allowing someone to apply for indefinite leave to remain once they've completed 10 years lawful residence in the UK. And the Home Office's own published guidance says that time spent as a British citizen must be counted as lawful residence. Indeed, it would be a nonsense if it wasn't. However, it is always open to the Home Office to refuse indefinite leave to remain on the basis of suitability grounds, owing to the previous deception which led to the deprivation. Therefore, if you are thinking of applying for indefinite leave to remain straight away, it would be sensible to provide as much evidence as possible of your good character, positive employment record, strong ties to the United Kingdom, to make any application as strong as it possibly can be. Of course, it goes without saying that before applying for indefinite leave to remain on the basis of lawful residence, the general requirements of paragraph 276b will need to be met as well, which is obviously passing the Life in the UK test, which you will have probably done before. And once you've done it, you only have to do it once, you don't have to do it again. Making sure you've got the English language requirement. Again, you may have to resit that because those tests can be for a short period of time, unless of course you've got a degree. And you cannot have been abroad for more than 548 days in the entire 10-year period. So there is some potential hope or scope for those people that have been deprived of British citizenship and have got the 2.5 years to actually go straight back on and apply for indefinite leave to remain. Whether it will be granted or not, that will depend on the view of the Secretary of State, but also on how much work you put into the application. So if you're interested in it, then please get in touch with me and I'll do my best to help you if you're suffering the threat of deprivation, you've got a deprivation process ongoing, or you've been deprived of your nationality and you want to get either limited leave or indefinite leave to remain. Anyway, do take care. Thank you very much for watching. Please subscribe to my channel. This is Paul Turner, the Immigration Barrister at Imperium Chambers.